stand by while NCLA cuts through the noise to signal abuse of administrative power. This is Administrative Static with Mark Chenoweth and John Vecchione.
Welcome to Administrative Static. This is John Vecchione, and I'm here with Mark Chenoweth, and we have an Amicus victory report, which I'm very happy about because we also have clients in Rodden v. Fauci who are going to benefit from this decision in Feds for Medical Freedom versus Joseph R. Biden et al. And this was a case, you may remember, where President Biden issued an executive order, 14043, which required all federal employees to be vaccinated. And there was a similar one for federal contractors. And so we sued in the same court in Texas, and our preliminary injunction was denied as maybe not, the government wasn't doing enough.
You were a week premature or something
premature,
like that.
But the fact is, all of the, and Feds for Medical Freedom then moved about 2-3 weeks after us, and they got the injunction. And then it went up to the Fifth Circuit, and a panel of the Fifth Circuit dissolved the injunction. So they moved for en banc, meaning all the judges take a look at it. And the en banc panel has come back with a really tremendous ruling.
And I was there for the oral argument.
I'd forgotten that.
Yeah, it was on the same day as our Cargill case, so I was there in the room where it happened.
Exactly, and I'd forgotten that. Well, and this really, this opinion is very strong, in that the key issue, I think the real key issue, was, is there jurisdiction? And appellate courts love that question, and
because they love to say no, there isn't jurisdiction. This is somebody else's problem.
This is someone else's problem. But here, nothing had really been done to the employees. President Biden issued the executive order, and they said that's unconstitutional. You don't have the power to direct all of our healthcare decisions just because we're federal employees. But there is a very complicated system, and I'll use some of the language from the case later on. But the Civil Service Review Act has you have to, whenever there's anything done to you in federal employment, you have to go to the Civil Service Review Board, and they get first crack at everything. And then there's a complicated appeal procedure, and then you eventually get up to the DC circuit, whatever circuit you're at. And the government argued that, hey, we've got these cases. We've got Elgin, which I know you've all heard of, most of you out there. We've got Thunder Basin. We have all these cases, and this is exclusive jurisdiction.
This is pretty nerdy stuff, John. I don't know how many people have actually heard of Elgin or Thunder
All right,
Basin.
that could be. But in any event, that the court went through and said, this is a pre-enforcement facial attack on the executive order. And so
by someone with standing.
And they have standing. And the reason they have standing is because this is a constitutional issue. And they cited Cochran. And they cited their recent decision in Cochran, which of course was an NCLA case.
Yeah, NCLA victory.
Now is now before the Supreme Court. And they said, look, Elgin versus Department of Treasury, that things had already been done to this employee. And so, it was a different situation. They first went to the text and the structure of the CSRA, and they noticed that they used something that it's pretty funny, because the way the CSRA is done with is a lot of small Roman numerals is how it's divided up. So they keep referring, and I don't know that I've seen it referred to this that often, but it's called, I'll find it later, but it's like reticule 2, reticule 3. It's a very odd word, but they say, look, this is the sort of thing that they say should be in the CSRA, but the other things in the list of what we say should be in the CSRA, like punishments, firings, demotions, this isn't like any of those things. And so it's not a CSRA covered personnel action. And and they say the italicized clause, covered personnel action, is very important for two reasons. Supreme Court has been clear that the CSRA eliminates 1331 jurisdiction. That's all district courts get to take a look at constitutional issues only for personnel actions covered by the CSRA. And they go through a number of times when it wasn't covered by the CSRA. And then they said
when other government actions weren't.
Correct.
Yeah,
correct.
okay.
And then likewise in Elgin, the court repeatedly limited its holding to the CSRA's jurisdictional effect on covered employee challenges. Covered. And they go through all that's covered. Well, that leaves the idea that they're not covered.
Yes, there are some uncovered ones.
Right. And so it says so CSRA does not strip 1331 jurisdiction when federal employees challenge something other than a CSRA covered personnel action. And they then point out one that I'd never read before, which was some government employee installed hidden cameras in a woman's changing area of a VA medical center.
Oh my gosh.
And then the government said that you couldn't sue on that until you'd been through, but what could possibly be the personnel action? There's someone just spying on you. For people who are interested, that's Gustafson v. Adkins, 803 F. 3rd 883, and I'd never heard of such a thing. But in any event, they said this was more like that than like an action. And so they go through all what the other circuits have said, and they say federal employees must bring challenges to CSRA-covered personal actions through the CSRA, but they remain free to bring other non-CSRA challenges under the district court's general 1331 jurisdiction. And that's good news because these pre-enforcement, these huge waves that cover every employee and are usually constitutionally challenged. It's not like, oh, no, I showed up on time at work. It's not that kind of factual decision. I think that's exactly it. And so
well, and it can be extremely costly if every individual has to
correct,
go against this individually instead of being able to do it all at once.
And time consuming. Who knows when it would get up there, right? And so I do want to point out. So they do bring up Cochran quite a bit, but they also say that look, this isn't a personnel action. That's what the government has to show. Romanet, that's what they called it. Romanet 12. Romanet. And Romanet 12 is a residual clause.
I think I like to say little I.
Yeah, exactly. That's what we always say. But it's Romanet. That is, I knew that was the case, but I had forgotten that word. And it says such residual clauses trigger the maxim estudium generis, which is one I've always loved this particular. It means it's basically like the old Sesame Street. One of these things is not like the others. And the statutory canon where general words follow specific words in a statutory enumeration, the general words are construed to embrace only objects similar in nature to those objects enumerated. So when they give examples, whatever you're trying to do as the government to keep it in the CSRA has to be like those examples. And this challenge to the president telling everyone they got to get vaccinated or they're going to have unknown consequences. Sorry, that doesn't do it. And they build on NFIB v. OSHA, which we also put an amicus in on. Yep. And that's the idea that OSHA said everybody in every workforce over 100 in the United States had to get vaccinated, and they had no power to do that. And they cite this. So all these cases are building on each other. And I think they're all telling the agencies the same thing, that just because you have authority in one area doesn't mean you have authority over everything everywhere.
Right.
All at once, as a movie might say. Well,
and general authority doesn't connote specific authority in other areas.
That's right. And so they bring up Judge Barksdale dissented, but they note that he agrees that this isn't CSRA covered, so he shouldn't be dissenting. I think is how they're doing it. The EO's enactment does not constitute an adverse action subject to CSRA. Case at hand is instead a pre-enforcement challenge to a government-wide policy imposed by the president that would affect the 2.1 million federal civilian workers, including the 6,000 members of Feds for Medical Freedom. So what they're explaining here is, look, he agrees with us on this sort of thing. So he shouldn't be disagreeing on this. But I think that they do hold that you can bring a facial pre-enforcement action against federal policies outside the CSRA, and that's going to be important coming down the line because I think presidents are always going to be doing this, Mark. They're going to have some political point they want to make. But
well, yeah, I mean, if this had been upheld, then you could imagine each successive president trying to order all federal employees to do all sorts of things that would been problematic.
And they also, I just want to bring up, they did cite Cochran. First, they're saying that that the majority relied on cases that predate Elgin, which the government says abrogated those cases. But as we recently held in Cochran v. SEC, 20th F. 4th 194, Elgin did not break new ground regarding implicit preclusion, nor did Elgin address pre-enforcement challenges at all. And the government's position entails that Elgin had held sub silentio. The court lacks jurisdiction in all its past cases. And they just weren't willing to go that far. And then they then knock out Thunder Basin. But they also, they note that the CSRA doesn't have this experience. All these agencies say, oh, we have experience and expertise. But they say, listen, this is a very, the CSRA is a winding road which cannot be driven by the, quote, easily carsick, meaning it's difficult. No part of it includes reviewing an executive order for compliance with the APA or ordering injunctive relief that affects thousands or millions of employees. No part of its Byzantine procedure is suited for or even appears to allow an emergency preliminary injunction. And the government does not cite a single case, nor have we found one, where OSC agreed in its unreviewable discretion to petition the MSPB for relief that remotely resembles what the plaintiffs ask here. So, and they also go third, Thunder Basin and talk about Cochran once again. So I think this is an important decision. I think that they've pretty much followed what we said about jurisdiction. They gave a shout out. They gave a shout out to Professor Amar, Akil Amar. We see him on a lot of Federalist Society things, and they said that the dissent wanted his view of jurisdiction, but the dissent got his view wrong, and they call it Amarian, which I think he's going to love, and I'm sure he's going to mention the next time he's at any of these Federalist things. So I think this is important, Mark. I think that these vast executive orders are going to be subject to challenge by any administration going forward. And certainly with this government, issues for purpose that will.
Welcome back to Administrative Static. I'm Mark Chenoweth. He's John Vecchione, and we are joined by our distinguished colleague, Richard Samp, who's Senior Litigation Counsel here at the New Civil Liberties Alliance, to talk about a recent victory that Rich secured for NCLA. Welcome to Administrative Static, Rich.
Well, thank you for having me.
So this case is in re bistolic antitrust litigation. And so that I don't immediately put the audience to sleep, let me just say a couple of words about this case, and then ask you to maybe explain what the significance is of this case. But to make a long story short, as I understand it, the accusation was that some of these major pharmaceutical manufacturers were paying generic manufacturers not to compete with them. And so what this lawsuit was over was sort of, is it an antitrust violation to pay a generic manufacturer not to enter the market or not to compete with you in the production of a generic version of your pharmaceutical? So maybe the first question, Rich, is, so why isn't that an antitrust violation, and what did the court say about that issue here?
Well, the first thing to remember is that the drug manufacturer held a patent for the drug at issue. NCLA has long been a supporter of private property rights, and patents are a form of property rights. The federal government provides that somebody who spends all the time and money and effort into inventing something new and useful for society,
like a brand new molecule,
sure, is granted a patent so that for a certain number of years, they have the exclusive right to take advantage of that invention. And then the way the laws work, after that patent expires, well, then other manufacturers can go forward and manufacture the same drug. And so obviously the price of a drug is higher so long as it's still under patent. And then after the patent expires, then generic manufacturers can jump aboard as well. Well, if a drug proves to be highly successful and a manufacturer is reaping significant profits from his patented drug, well, immediately generic manufacturers want to jump in as well. They want to be able to share in that profit. So the first thing they try to do is to figure out a way to challenge the validity of the patent, because obviously not every patent that is issued is valid. And so if you can find a loophole and find a way to get it struck down, well, you can share in those profits. So that happens all the time for successful drugs.
Pretty much every time, right?
Yeah. If you've got a successful drug, you are going to have your patent challenged. And that's what happened here. And eventually, the litigation over whether those patents were valid was settled. And
which happens with a lot of litigation.
Sure. And the settlement actually resulted in the generic manufacturers being allowed to enter the market at a period of time before the patents were scheduled to expire. So that was kind of a win-win situation.
And in fact, another type of litigation that goes on is sometimes they have a patent for a certain reason, for a certain treatment. And the question is, when do the generics get in? Is sometimes just that question is litigated.
Sure. So there's litigation like this all the time. Well, the trouble is now in recent years, antitrust lawyers are trying to get in on the fun. Once this patent litigation settles, then the very first thing that antitrust lawyers do is you're saying, oh, well, gee, because the generic companies gave up their right to jump into the market early before the patent expires, that must mean that the antitrust laws were violated, because obviously the generic manufacturers were paid off to settle the litigation. And if only they had litigated a little bit harder, then consumers would have been helped, because they would have been able to get into the market sooner and prices would have come down.
So this is collusive.
That's the argument that is made. And so what the judge in this particular case ruled, well,
this is Judge Louis Lyman of the U.S. District Court for the Southern District of New York. And if that name sounds familiar at all, it's because his father, Arthur Lyman, was a famous attorney in Manhattan, and I think wasn't he the district attorney for the Manhattan District
Attorney?
I think
he was U.S. District, yes.
U.S. attorney or district attorney in Manhattan for a long time.
And Judge Lyman recognized that there will be some cases that the evidence showed that the generic drug manufacturers were really paid off millions of dollars not to compete. But what was done here, what Judge Lyman said was, no, the complaint does not allege that there were any improper payments made, and for that reason he dismissed. Well, what the antitrust lawyers tried to argue was, well, of course, there was a lot of business going on between the generic company and the inventor of the drug, the innovative company, and that business, if you looked at it carefully, well, maybe money that was paid by the brand name manufacturer was in excess of the market value of what was being done by the generic manufacturers in return. So let us go forward and
get some discovery.
Sure. And then, of course, once you get past the initial pleading stage and you get into these cases, then of course the drug companies have to pay off millions of dollars just to make the case go away,
because the cost of discovery is so expensive.
Sure. And what we were particularly happy about was we filed a brief, NCLA filed a brief in the case that said, look, if you're going to look into the question of whether or not improper payments that were really large were made, you ought to define what constitutes a large payment in a way that is reasonable. And Judge Lyman, in a lengthy section of his brief, said, we agree with the brief filed by the NCLA in this case that the way to determine whether large unjustified payments were made should be done in a way that is reasonable and doesn't just simply take the party line of the antitrust lawyers. And so he applied the standard that we said should be applied. And as a result, he said the antitrust lawyers had not shown that anything improper went on here. So this was a victory for consumers and for the patent system and property rights, that property owners should be happy that judges like Judge Lyman are willing to uphold property rights and to say the patent should not be struck down simply because antitrust lawyers want to get a payday.
How common is it, Rich, in your experience? You've written a lot of amicus briefs in your life. I hesitate to think how many you've written, probably hundreds for sure, maybe 1,000. How often or how frequent is it that a judge will cite an amicus brief, either one that you've written or one that someone else has written by name in an opinion? Is that something that happens very often?
No, I can count that happening in probably one or two hands. That it's only when an amicus raises an issue that is perhaps a little bit different than what the parties are arguing. So it really was if I do say so myself, kind of a feather in our cap to be
Absolutely.
mentioned.
No, I think it was great. I mean, it certainly perked up when I saw that and learned about it. And hats off to you, Rich, if we're going to keep with cap metaphors, for your good work on this amicus brief, because I think that it obviously was persuasive to Judge Lyman. And you don't always know. You always hope when you file an amicus brief that the court reads it and that it's persuasive to the court, but you don't always know that they've even read it, let alone that they were persuaded by it. And here we know both. We know for sure he read it and he was persuaded by it. So that's a fantastic achievement, and I'm thrilled. Now, I'm a little bit afraid we're going to be inundated with requests for amicus briefs and antitrust cases now. So just if anyone's listening, that's not something we really do very often at all. So you might not want to bother asking. But is there wider significance to this case outside of the antitrust context, or is this pretty much limited to this pharmaceutical context where these cases come up over and over again?
Well, the whole idea that plaintiffs should be able to get discovery in a case simply because they've alleged that there's a violation of the law is a real problem area. And this decision by Judge Lyman is an excellent reaffirmance of what the Supreme Court said in a case called Iqbal and another case called Twombly, that plaintiffs can't get all the way to a trial simply by making allegations. Instead, they have to allege facts to support their allegations. And in this case, Judge Lyman said, you didn't allege enough facts. Merely claiming that it was a collusive agreement is not enough. You have to show some evidence to support it.
And is this going to go to the Second Circuit?
Oh, no question about it. Yes,
Nice.
They've already filed their notice of appeal, and so this is going up. And this is really this issue about drug patents is a hot area. So people will be following this case very closely.
There's a lot of money sloshing around, willing to pay for work in this area, but not for amicus briefs from the New Civil Liberties Alliance.
No.
This was a pro bono effort. So, but maybe that's part of why the judge finds it persuasive. I don't know.
I hope so.
That could be. So I think you already spoke to this a little bit, Rich, in terms of pharmaceutical prices. But why should non-pharmaceutical manufacturers care about this case? Is there something here for your average consumer to care about?
Certainly, I think average consumers want a strong patent system, because without having a strong patent system, we really we don't provide enough incentives for people to come up with new and useful products. I think that the American economy has been built on innovation, and we need that to continue.
Absolutely. Well, for those who want to follow this in depth, again, it's in re by Stolic antitrust litigation. Judge Louis Lyman in the U.S. District Court for the Southern District of New York, and you can follow that on appeal at the Second Circuit. And congratulations again, Richard Samp, for your amicus brief in this case for NCLA.
Well, thank you.